I don't know what more of no tolerance you don't get. Your device has been dead.
So Judge, I don't think it was low and then it went dead for, I think, a couple of days, but he didn't receive, well, I understand that, Judge, but he didn't receive, I guess the device supposed to send something.
You know when you're supposed to charge the device. You know.
I think it gives you a notice or something that is dying out. And so it didn't give him notice. So he went to pretrial service to have him check it out to find out what was going on with it. But he's been on bond for a very long period of time with no issues whatsoever.
That doesn't give you the justification to do what you're doing.
Judge, I will say that I contacted the device people over at 49, whenever he reported yesterday. They stated like
He only reported yesterday.
yes, we observed.
Unacceptable. Unacceptable.
Well, no, Judge, he reported because I told him that the device, that this was filed. That's the only reason why he reported over there.
The only reason he cared enough to go was because you told him he had to come to court. Otherwise, it would still be dead. It would still be non-functional.
I don't think that's the case, Judge, because it's been functional the entire time that he's had the device. So this is not he's been out for 2 months and the device has not been functioning. That's not it. This was just filed 2 days ago.
Because I wanted to take care of it now. And the reason is that he's on probation for a violation of protective order, picks up an assault of a pregnant person, and then picks up another assault of the same person. And he has another assault dismissed, and they're all the same person. And I told you that there was no tolerance in these cases. And I have here that you have a dead battery since 2/10 of how long was the battery dead?
According to the viewer, I believe it started on the 10th, and then whenever he reported for.
Yes, Judge, that's what I'm saying.
Reported for inspection, we found no issues with the device itself or the charger.
Revoking your bond. You're going to jail. I'm sorry. Bond conditions, bond conditions. There's no justification, right? 3 open cases. I've repeatedly told you, no tolerance, and you're just doing whatever you want to do. You're not charging it. Goes dead. So does the bond.
Judge, it went dead on the 10th, and he immediately went in to go have it checked out because he didn't know.
No, he didn't. 2 days later, because you said you got to come to court, it's probably a good idea for you to go get it checked out.
That's not how it happened, Judge.
Tell me.
When I got the email, I said, hey, there's an issue possibly with your device. He said, I got no notification whatsoever that it was dead. So I will go down there and check it out to see what's going on. I didn't tell him about a court date because I didn't know about the court date at the time. I got the motion first. Then your letter came after the fact. So he went on his own to have it checked out. So if you look at the records, I mean, he's been out for a while and this just happened. 2 days, that's it, Judge.
They tell you that you're supposed to charge this thing on a daily basis. They tell you that you need to put it by the charger every day for a specific amount of time. And if you don't, the battery goes dead. So you know what you're supposed to do.
I understand that, Judge, but also if the court remembers that he is also keeping a newborn baby, so maybe he put it in.
That's
He was tired. I mean, I don't know, Judge.
it's been dead for 2 days.
It's only been there for 1 day, I believe, Judge, because he went on the 11th, I believe. Today's the 14th.
No, she said yesterday he went. Today's the 14th. That's the
Today's
13th.
14th, I'm sorry, that was the 12th. I don't know why I thought it was the 13th.
So when did he go?
The 12th.
No, the battery goes dead on the 12th. When did he go to pretrial?
He went to pretrial on the 12th, Judge. His battery went dead on the 10th.
Oh, I'm sorry. Okay, battery goes dead on the 10th. Goes to pretrial on the 12th. So he's without a device 2 days. I'm sorry. Goes with you. Just not getting it. I don't know what to tell you, Ms. Jewett, right? There's just no justification. I have 4 kids. It'll take me 2 minutes to put them in front of an iPad for me to go do what I need to do to go wash the dishes, to go take the dog out, to change the litter.
Well, I understand, Judge, but I mean,
There's no excuse. You've got 3 open, very serious cases. And I told him at the outset when he picked up the last violation of protective order, there's no talk. I mean, you must comply strictly. And he's just not doing it.
just gonna just reset it for reconsideration on this bond, maybe 2 weeks, a month.
So here's the deal. You were right. These cases are ripe. They're old. And it's time to do something with them because the thing is, and what I've experienced is that when we take too long with cases, something invariably happens. You know, cases should only last so long because certain people need certain things. And when they're not getting it, they tend to fall in familiar habits. So these are too ripe. Let me see how old these are.
And if you remember, this case was actually transferred over to the,
Herreri?
yes,
Right. Now I'm gonna keep it now, just because it's, just too much drama. So the violation case is 256 days old. The new violation case is 136 days old. Is discovery complete in both cases, please?
Yes, sorry, last
The
name
newest
is
case is discovery complete.
correct.
yes, and Judge, if you remember, you may not remember, but this is the case where the wife is saying that what occurred is not really what occurred. Remember, this is the toxic case.
And Judge, either way, discovery is complete on the case.
Do you have an offer on these cases?
On the most recent VPO, there is not, let me see if,
Can you please put an offer so we can,
I'll let DVD know that you're requesting that they put an offer on.
please?
Yes, Judge.
And is there an offer on the felony case?
On the felony case, Your Honor, let me see. There is not, Your Honor.
Because the problem, Judge, is they were supposed to be working on the fact that the wife came to court and told the prosecutor she's not participating. So they were going to reeval. That was 2 months ago.
If I may, they did offer him a 2-year deferred upstairs.
Oh, they did?
Yes, Judge, it's just in the notes, not in the actual. They're having a conversation about going back and forth with the defense attorney on that case
Okay.
to see what they want to do.
So you're set up there 228, okay? We can set the day after if you'd like.
That's fine.
Okay, and then what I would suggest is when we come back, it's, plea or trial time. So we can just put these babies to bed once and for all. And perhaps the felony court will, you guys can make a global resolution. I don't know, but it's, if I don't do what I'm doing now, I'm enabling. And I'm saying it's okay for you to do what you're doing without any consequence. And it's not. He has to understand that there's consequence. This is the 4th time, it's over and it's over and it's over. And I can't.
Understood, Judge.
And I understand that you have to zealously advocate, and I'm not begrudging you for doing it, right? Certainly not. Of course not. But I can't continue to enable him, So, okay, you got it. Good morning, Mr. Guzman. How's jail? You're here with your lawyer. Your lawyer's on Zoom. I don't know, the TV's not working, but he's here with you. We have appointed Mr. Duong to represent you. You are on probation in this court for driving while intoxicated. Can you just put that right there in front of him, please? Right there. You recognize that?
Yeah.
Okay. We're going to do probable cause. I'd like to know what happened on so what happened is you're on deferred in this court for the DWI. You picked up a felony possession of a controlled substance. You also picked up an unlawful carrying of a weapon. I have no idea what happened on those cases, so I'm like to hear what happened.
Yes, Judge. On February 11th, 2024, the officer observed a silver Chevy Silverado traveling on the 2400 block of Little York Road in Houston. The officer ran the vehicle and it returned as a white Chevy pickup truck. And the officer knew that the truck in front of him was not white in color. Therefore, the officer initiated a traffic stop. The defendant immediately opened the door and attempted to get out. A high-risk stop was initiated and the defendant complied with instructions. The the defendant was detained, and the officer observed an NL sticker on the vehicle, which the officer knows stands for Mexican State of Nuevo Leon. The officer observed in plain view a glass pipe connected to a plastic bottle from which training experience known to be consistent with drug paraphernalia. The officer located a clear crystal-like substance consistent with meth, and another officer located a handgun behind the passenger seat.
I'm sorry, you picked up with us the unlawful carrying of a weapon. I'm going to find that there's probable cause to go forward with your case. So, John, it looks like felony court is set for the 17th. Do you want to set it perhaps for the day after to see what happens up there?
Sounds good to me, Judge. And then I'll, Mr. Guzman, I'll come by the jail to talk to you further. Okay?
Okay.
I'm ordering you as a condition of your bond on both cases not to drive any vehicle whatsoever for any reason. And they gave you a PR bond on your gun case. I don't know if that was a smart move. You've not made bond on the DWI as it is, so I don't know. We'll see about the PR bond, but do not drive. I don't know if you're going to get out or not. If you do, you will get a GPS monitor because you are a flight risk. I find by clear and convincing evidence that you are a flight risk. As a result, you will get a GPS monitor, and I'm also going to give you a curfew from 7 p.m. to 7 a.m. Do you understand? You are not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're using, likewise, you will go back in.
I haven't. Want drug test?
Well, I can't while you're in jail.
Okay.
But if you do get out, trust me, Mr. Guzman, you will be tested frequently.
Okay, that's fine with me. I haven't been using drugs.
So what I'd like to do also is do a TRAS to see where we go from here. I don't know, quite frankly, I don't know where we go from here. You're on probation in this court, and I don't know, because what we typically do is we do evaluations to see, because I have clinician on staff to see how we go forward. I know you tell me what, it's like little bunnies jumping in the woods, but the fact remains is that you've picked up a new case, you absconded on our case, we had issues with that, now we've got issues here of what happened with these cases, so we will have you evaluated to see how we go forward. And I don't know, they may say residential treatment, they may say outpatient treatment. I have no idea, but that's why I have clinicians on staff, because they are better. They have the tools to tell me how to go forward, because Mr. Guzman, I just don't know you.
I'm just trying to get rid of this stuff and get over with. I don't want to be up in here as much as you want to see me up in here.
So if you don't mind setting them up for a TRAS, and then we'll go from there. So John,
The reset date was 3/17, Judge?
no, he's set for February 17th. So next,
Okay, I got you. So he's going to
on Monday, he's set for felony court. So I guess we'll do, the next day, and we'll figure out where we go, huh?
Yeah, I'll have to zoom in, Judge, because I'm out for the rest of next week. So I mean,
Okay, yeah, no issue. No problem. That's where we have it, okay?
so the 18th.
Yes.
Okay, gotcha.
Okay.
All right, Judge. Thanks. All right, Guzman, I'll talk to you later.
So do you mind those conditions, please? And we'll have him sign it. All right. All right, man.
All
Good
right,
luck.
thank you, Judge. Have a good weekend, man. Excuse
You
me.
too, man. Happy Valentine's Day.
You too.
So you're charged with terroristic threat. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On August 1st, 2024, the officer was dispatched to a disturbance call, and upon arrival, the complainant and security staff stated that the defendant made threats to kill everyone, broke 2 hospital monitors, and was acting aggressive towards the medical staff. The complainant stated the medical staff became scared since the defendant stated, "I will kill you all." The complainant stated she was scared for her life since she did not know what the defendant would do next at that moment.
That doesn't sound right, because I didn't do that.
Give you a lawyer, and we can go through this with the lawyer. So Did he direct it at a person? Is he directing at the entire world? What?
The statement was only made that I will kill you all. And it says the complainant stated the medical staff became scared and the statement was that I will kill you all. That's all we have from the DMs, Your Honor. And then furthermore, the complainant did state she was the only one at the hospital at the time of the officer's arrival, since the rest of the medical staff had gone through a shift change and she was the only one there. So it's not exactly clear who was there when the statement was made. He just said, I will kill you all.
Right, so who's it directed to? Just,
I don't even know that.
The DMs does state that the defendant started to act aggressive towards the medical staff.
and
So
I think that's why she was scared, right?
it appears that because it follow on saying the defendant was, the complainant said she was scared and the medical staff was scared since he stated, I will kill you all. So it appears that it was directed towards the medical staff as he was acting aggressive towards the medical staff.
It appears.
Because there's just two
A
distinct
hunch.
There's two distinct sentences, Your Honor, where he acted aggressive towards the medical staff and the complainant stated the medical staff became scared since the defendant stated, I will kill you all.
I thought he did time for that too.
Mr. Mkish, I'm going to find that there's no probable cause to go forward with your case. But you need to be careful.
Yeah.
Scaring people can kind of hurt them. You know what I mean?
Your Honor, I don't,
Look, don't. Mr. Mkish, patience goes a long way.
Yeah.
You know, when you get upset and when you lose control, that's why we have so many people in jail, because they lose control, they do whatever they want to do, and they don't think, if I do this, what's going to happen? If I say this, what's going to happen? Be careful. All right? All right, just hang tight for me in the back. All right, Ms. Fernandez, you have been given 2 PR bonds, and your case is nearly 250 days old. They are still allowing you to take this plea bargain agreement where if you complete a class, your case will be dismissed. They are giving you only until Monday. So what we will do is we will reset your case until then. If it's not done, we will have to go another route. If you ever miss court again, you will not get any more PR bonds. That will be the 3rd time that you have failed to appear for court, and it will not go well. Do you understand? You have a lawyer. It is your responsibility to stay in touch with the lawyer, and they can always get a hold of us. But there's no excuse. No tolerance anymore. Okay? Good luck.
Thank you.
You are charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes, Judge. On February 9th, 2025, the officer was dispatched to an assist the officer call in regards to a shots fired at 1700 Travis Street. The defendant was detained because the officer observed an unidentified individual discharge a firearm and the defendant was within that group of people. The defendant admitted to the officer that he had 2 ecstasy pills in his right front pocket and that there was an AR pistol in the SUV the defendant was driving. The officer completed a search of the defendant and located 2 methamphetamine pills in his front right pocket, and the defendant informed the officer that he was aware of the AR pistol in the SUV prior to him getting behind the wheel. The officer located the AR pistol on the floor in the 2nd row of the SUV within reach of the driver. The substance was believed to be methamphetamine based on training experience with a weight of 0.61 grams.
Husband, I'm going to find that there's probable cause. Wait a second. He says that the AR is his?
He says he was aware that it was in the vehicle and it was within his reach in the vehicle.
Whose vehicle is it?
I don't believe it says in the DMs, it says he was driving the vehicle.
How do you put it on him?
Allow me to read the full DMs, Your Honor. Yes, Your Honor. He says that he was driving, so it would be that he was in care custody control because he was operating the vehicle with knowledge that the firearm was in there and it was within his reach, his ability to grab the firearm.
Diego Camacho?
Not. How do we know that how do we know that it was in there while he was driving? How do we know that they didn't put it in there after the fact?
The defendant stated that he was aware that the AR pistol was in the vehicle before he got into the driver's seat, before he started driving.
No. It just said that he was aware. Don't add stuff in.
I'll read the complete dim.
Read it.
It says the dim states completely that the defendant informed the affiant, the officer, he was aware the AR pistol was in the SUV prior to him getting behind the wheel, and the defendant informed the officer that the AR pistol could be found in the SUV at the time of his arrest.
Are we to assume that it's his? All he says that he knew that it was in there. You know, it's not his car.
In your honor, just as cited, the pleading is that it was on or about his person. So we're just saying he was in his possession because it was in the vehicle he was operating with knowledge that the AR was in the vehicle as well as it being within
Do you even know when he was operating the vehicle?
I apologize. What do you mean when he was operating?
Was he operating it in the morning, in the afternoon, at 9 o'clock at night? When did all this transpire? What time of day is this?
Let me see, your honor, because based on the dims that I see, it appears that
There's a group of people.
it appears
right?
that the defendant was, according to the dims, the defendant was found to be at the wheel of a black GMC. So when the officer arrived, he was observed within the vehicle from what the officer says.
Was in the car at the time
At
the
the
cops
time.
get there.
From what the officer says, that he was observed behind the wheel of the vehicle. To be at the wheel of the black GMC Suburban bearing a license plate number that is in the dim. So it,
Okay. All right. Husband, I'm going to find that there's probable cause to go forward with your case. I mean, we take it seriously. I want to make sure if there's enough probable cause that's, you know. So I am ordering you as a condition of your bond not to be in possession of weapons. Do you understand? If I find that you're a danger to my public, I only have one place for you. So don't. That includes everything. Do you understand, Mr. Husband? Do you mind filing no weapons, please?
Yes, Judge.
You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you because you're ducking, you're dodging, you pick up a new case, it's not going to go well for you. You understand? All right, I'm going to have you sign a receipt, Victoria. We'll have you take a seat in the juror box and get your bond conditions. We'll have you sign it, and then you're free to go. All right?
Yes.
Mr. Williams, you were charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 8th, 2025, the officers were dispatched to a disturbance call. The officer met with the complainant, who stated that she and the defendant were in a 7-month relationship. The complainant stated that she shoved the defendant with her shoulder and that the defendant then grabbed her and threw her around. The complainant advised that the defendant was grabbing her face and neck area and has pushed her to the ground, causing pain. The officer observed a laceration on the complainant's hand and a swollen lip. The officer made contact with the defendant, who stated that he lost control and that he admitted to shoving the complainant.
Williams, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with this person. Do you understand? If you have contact with this person, if I find that you're in possession of a weapon, I'm going to revoke your bond, put you in jail. No more PR bonds. I want my community safe. I don't care who it is, what color they are, whether they're a small farm animal, I don't care. Everyone gets protected. Do you understand? Do you have the ability to hire a lawyer, Mr. Williams? Okay, I will take a look at an affidavit. I'll see whether you qualify, and then I'll have you take a seat in the jury box. I'll have you sign a reset with Victoria now. Do not leave until you sign our bond conditions. Do you understand? And then I'll have you talk to a lawyer here momentarily.
I work with her, so
I'm sorry?
she worked at the same on
That's going to be an issue. I don't want you to have contact with her. Actions have consequences. Did you get appointed, Mr. Williams?
Yes, Your Honor.
Great. I wanted you to look at probable cause to see if you guys had any issues with it. That's why, or wait, no, maybe that was another case. Okay, tell me.
We were approaching, there's a MOEP and bond conditions that have no contact. The parties no longer live together, but they work at the same place, and there's a chance that their schedules could coincide with each other. State's okay with no threatening and harassing, but.
Have you reached out to the complaining witness? Do you
Yes,
know?
so, I mean, she's not on board, regardless, but I confirmed that they don't live together, so my suggestion was to have no threatening or harassing, that way both of them can work.
But I want to make sure that
The re-
she's, protected, that she doesn't have any kind of fear.
Yeah, she's not really concerned, from my understanding. But I would suggest, just keeping the residency restriction so that, because they don't live together,
Mr. Williams, come up.
and then just, keep the no threatening or harassing contact for that purpose.
Good morning. So your lawyers asked for me to modify your bond conditions to say no threatening or harassing. I will acquiesce, but you have to understand what is threatening or harassing. Doesn't matter what you think. It's what she perceives. So if I'm going like this, is that threatening or harassing? It most certainly is, and it can get you in trouble. I don't know what kind of relationship you have with this person, but if it's a type where you're constantly butting heads, you got to be careful. There are many, many vindictive people in this world, and you never know if all they got to do is call, hey man, he's doing this, he's doing that, and then you're going to end up back. So you got to be careful. You understand? Okay. So the only thing I'm doing is I'm modifying the conditions. So no threatening or harassing contact. The residential restriction will still apply. So you cannot go to the house listed in the order for protection. Any more questions, anything?
No, Your Honor.
Okay. All right. Good luck.
Judge, you want me to refile that? Because I know the language that's typically in there.
Yeah, I would, just in case. So it's like nice and clean. Yeah.
That's good. I'll file that now.
Thank you, Judge.
Oh, and no weapons too. Okay. Mr. Kamacho, you're charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 7th, 2025, officers were dispatched to Hardy Road in Harris County, Texas, in regard to a minor crash, failure to stop and give information call. Upon arrival, the officer spoke with the complainant, who was also in police uniform. The complainant stated he was driving on the freeway when another vehicle got into his lane and cut him off to make the exit. The defendant got over and hit the front right panel of his truck with the back driver's side of the defendant's vehicle. The complainant followed the defendant, who had his hazards on, but the defendant did not pull over. The complainant continued to follow the defendant's vehicle until the 911 operator told him to stop following. The complainant gave a description of the defendant's vehicle, and a license plate number to the dispatcher. The complainant pulled over and waited for the officers to make a report with an estimated damage of $2,000. The officers ran the license plate and found the vehicle registered to an address on Skinner Road, and the officers traveled to the location and met with the defendant and his father. The officers were given consent to enter the property to look at the vehicle and observe damage. The defendant stated he was crossing the lane to get over because there was an opening and that the truck accelerated and hit him. The defendant stated the complainant already hit him and was close behind him, so he kept going. The defendant stated he turned down his street and the complainant kept going. The defendant's address is approximately 7 miles from where the accident occurred.
Okay.
And so, Judge, if I may, the complainant was only stopped following him while he had his hazards because he was told on the 911 call. And also, I see on the summary that when they run his license plates, this license plate is GS9711, is missing a letter. License plates are usually 3 letters, 3 and 3 numbers. So I'm not sure how running the license plates will go to his house. And additionally, if the correct license plates were also run, then it would actually show that he's not the owner of the vehicle. So I'm not sure how they were able to identify.
Well, somehow they got to the house, right?
Yes, Judge. They ran it and they got to an address and they went there and met with the defendant.
And then he states that he was driving, right? And the collision occurred, and then he took off. Your license plate, I have no idea. I mean, did they have the full license plate or did they not?
Your Honor, at this time, I don't know. The DIMS just states, as counsel said, just GS9711. So I don't know in the full offense report if it says the full license plate number, but either way, they ran a license plate and they returned.
Somehow they were able to get it to him. I don't know. I mean, if you discover something later that's different, come back and we can revisit probable cause. I'm happy to do it at any time.
Yes, Judge. And so the reason I say that is because I have the tags for that vehicle, and that's not the license plates that we have on the summary. And that's the
I mean,
only reason.
really, we'd have to set it for a formal hearing.
Okay, Judge.
Because I have to give them time to be able to respond to that as well,
That's
because
fine.
that's more, I mean, this is just a mere probable cause here.
Your Honor, in the OR, there is the complete license plate. It's the RSG and it continues on. So
I'll check on that, yeah. That's fine, Judge.
So you're saying it was in the DIMS?
in the DIMS, it was missing a letter, but in the full OR, they have the complete license number.
Pull the 911 tapes, see what the 911 tape
We'll wait
says,
for
right?
that
It may
finish.
be different, maybe they'll have the whole thing on the 911 tape, So, Mr. Camacho, I'm going to find that there's probable cause to go forward with your case. Have you run his license? See, he has a valid license.
We're ready, Your Honor.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand?
Yes, sir.
That is a condition of your bond. So if I find that you're driving and you don't have a license or you don't have insurance, I'm going to revoke your bond. I'll put you in jail. No more PR bonds.
Eligible, Your Honor.
You understand?
Yes, sir.
Okay, now you have a lawyer. Good job having a lawyer because you do. I will waive your appearance, but it is your responsibility to stay in touch with her. You don't have to come back to court. She'll let you know when you have to come back to court. All right? All right, I'm going to have you sign a receipt of Victoria. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it and then you'll be free to go. All right? Thanks. Yes, ma'am. You are charged with driving while your license is suspended. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
It's judged. On February 3rd, 2025, at 11:40 a.m., the officer ran a license plate search on a vehicle and found the vehicle to have expired registration. A traffic stop was then initiated. The officer notified the defendant for the reason of the stop and asked for the defendant's driver's license. The defendant provided a Texas ID that did not belong to him, and the officer asked for a name and date of birth. A search of the information provided showed the defendant's driver's license to be ineligible, and the vehicle also did not have valid insurance. And the officer did a person search on the defendant and found the defendant had a bond condition for an ignition interlock device, and that the vehicle did not have the interlock. The vehicle is registered to the defendant.
Let's go through your stuff. And I'm just from 2009. DWI, possession of a controlled substance, robbery, theft, possession of a controlled substance, felony theft, felony theft. Here's my concern. 2018, DWI second. 2019, DWI second. 2019, possession of a controlled substance. Further in the year, DWI second. Possession of a controlled substance, and now another DWI, and now driving on a suspended license. I don't know if you watch the news. Every single day, someone dies from an alcohol-related collision in our county. Every single day. Watch the news. It's really, really unfortunate when a button on a phone and $30 on an Uber will get you to anywhere you want to go in this damn county. Don't matter where you want to go. It's a geographical oddity. It's so easy to just hit one button. I don't know what we need to get through to you, Mr. Benjamin, but I don't know if you're going to bond out. You will be signing an affidavit with me today, promising me you're not going to drive. And I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing. Every single time you get behind the wheel, you can be facing 6 months in jail and up to 6 months in jail and or a $500 fine. Do you understand? Do not drive. It's really scary what happens every single day in our county, and it's so tragic. Don't drive. This is the promise that you're going to make to me. All I'm begging you to do is don't kill someone. Please, don't kill someone. You're being held at no bond on your DWI third upstairs as it is. And I don't know. Right now, they gave you a PR bond in this case, and I don't know if that's appropriate because you scare me. You just, according to this, I find by clear and convincing evidence that you just refuse to comply with bond conditions. So I don't know if I'm going to give him a PR bond. You know, he's driving a car here. He's supposed to have an interlock. He doesn't have one. And so I don't know. So for now, I'm going to have you sign the affidavit. It is a part of your bond condition. Don't be a danger to my county. Otherwise, I will make your bond very, very high. Do you understand? Get a clue, Mr. Benjamin. It's not hard. Come on. You're Lauren Thompson. Ms. Thompson, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
One moment, Your Honor. It's Thompson, correct?
Oh, sorry.
Okay. Okay. On February 8th, 2025, the officers are traveling on 4300 Luella Avenue in Deer Park and observed a motor vehicle driving with an expired license plate. The officer confirmed with TCIC and CIC and performed a traffic stop. Upon making contact with the defendant, he observed bloodshot eyes, slurred speech, and a strong odor of an alcoholic beverage. The defendant admitted to consuming 3 alcoholic seltzers, and standard field sobriety tests were administered. HGN 6 out of 6, walk and turn 8 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and refused to provide a sample, and a blood search warrant was signed and executed.
All right, Ms. Thompson, I'm going to find that there's probable cause to go forward with your case. Any prior to DBIs, and does she have a license?
No priors, Your Honor, and I'm running her license right now.
She doesn't have any priors.
I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. As long as you're not using, everything will be fine. If I find that you're consuming alcohol, illegal drugs, I'm going to revoke your bond, put you in jail. Do you understand?
Yeah, we'd like to state that she did tell the officer that, she had, taken some medication. So she did explain to the officer that she was under some medication. So we would like our concern is the revocation of her license. There's motions for.
I'm not revoking your license. I mean, you may continue to drive, just if it does become suspended at a later point, you just have to be cognizant of that it does, that you're not allowed to drive. So just be careful. You know, I don't know what's going to happen with the ALR hearing and all that. So just be careful. Now you have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with her and she'll tell you if and when you have to come back to court. Just don't consume alcohol. Don't use illegal drugs. If you're taking or no unprescribed controlled medication. If you're taking medication prescribed by a doctor, that's absolutely fine.
You tell us, Your Honor.
Okay, just understand that if you're taking a controlled substance, even prescribed by a doctor, if you take too much, it can be an intoxicant. And if you get in a car, it's bad news. So you just be very, very careful. You understand? Okay.
Thank you, Your Honor.
I'm going to have you sign a receipt. Victoria will have you sign your bond conditions for Fleischer, and then you guys are free to go. Thanks. That way. Good morning, ma'am.
Good morning.
I don't know if the TVs are working, but your lawyer's here with you on Zoom, so you know you're not alone. Okay. Ms. McElveen, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. Okay. On February 28th, 2025, the officer observed a vehicle run a red light on Derry Ashford and Westheimer at a high rate of speed. And upon catching up with the vehicle, the officer observed the vehicle run another red light at Kirkwood and Westheimer, both intersections in Harris County, Texas. The vehicle was estimated to be traveling at 80 miles per hour, and a traffic stop was conducted. The officer observed glossy eyes, slurred speech, and the defendant was unaware she had run the lights. The officer asked the defendant to exit the vehicle and observed a strong odor of an alcoholic beverage and an empty container of an alcoholic beverage and a half-empty open container of wine. Standard
Drinking while driving?
There were open containers, Your Honor. And standard field sobriety tests were conducted. HGN 4 out of 4, walk and turn 7 out of 8, one leg stand 3 out of 4. And DIC was read. The defendant consented to breath. The results were 0.146 and 0.144.
And I'm going to find that there's probable cause to go forward with your case. Are you telling me that she's consuming alcohol while she's driving, Alex?
Let me read the full judgment, Your Honor, and see if there's any.
I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you consume alcohol or illegal drugs, then I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand?
Your Honor, they were just partially full. There's no indication they were cold to the touch or anything like that.
There is no observation of her drinking while driving.
And then I'll run your license, Your Honor.
Anytime you have an open container in a car, it's a minimum of 5 days in jail, flat to any sentence that you get. I would hope that it's elementary that you don't have alcohol in the car while you're driving.
Eligible, Your Honor.
All right, you have a lawyer. Because you have a lawyer, I will waive your appearance. However, you must stay in touch with Mr. Dietrich and he'll tell you when you have to come back to court. No alcohol, no illegal drugs. If you do not have a Texas driver license and liability insurance, you're not allowed to drive. So if you don't have liability insurance in your name, do not drive. It is a condition of your bond. Do you understand? All right, I'll have you sign a reset with Victoria. We'll have you meet with Fleischer for your bond conditions, then you're free to go. Mr. Herreri, you're charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes, Judge. On February 6, 2025, the officer was notified by a witness that a former student, the defendant, was inside Spring High School. The defendant was unenrolled from the school by the associate principal on February 4, 2025, and was told not to return. Spring ISD school records show the defendant is no longer an active student, and the school officer and associate principal advised the defendant to leave on February 6th a second time, not to return. The officer observed the defendant walking on the walkway with other students, and the defendant continued to walk in the officer's direction. The officer observed the defendant pull his hoodie over his head while walking towards the bus ramp area. The officer was in full uniform and gave the defendant a verbal command to stop and follow the officer to his patrol vehicle. The defendant disregarded these verbal commands and began walking in the opposite direction. The officer grabbed the defendant by his left arm and the defendant began to resist, pulling away to the point where he started coming out of his hoodie. The officer verbally commanded the defendant to stop, and the defendant broke loose and used evasive foot maneuvers to gain distance from the officer in the direction of an open parking lot. The officer notified Spring ISD police and requested assistance. The defendant was detained 300 yards from the initial interaction.
So he was where?
He was at Spring High School.
I know, but was he in the outside or was he?
He was on the outside walking towards a parking lot and walking with a group of students when the officer interacted with him.
He's outside. Was he, any
Still on
point?
the property, Your Honor, of Spring High School, and they told him not to return to that high school. They told him on the 4th of February not to return to the high school, and he was
Yeah,
on the
I
property.
understand that,
Mhm.
but he's on the outskirts, he's on the sidewalk.
He was walking on a walkway with other students.
Walkway of the school,
It was
near the parking lot of the school, which is owned by the school.
Yes, Judge, it was the walkway with other students, and that's when the officer saw him and tried to make contact with him.
I mean, I'd like to know where, you know, is he on public property? Is he just on a sidewalk on the outside of the school, you know? Just walking?
He was with other students on the walkway walking towards the
Is
bus.
that,
Further in the DMs, it describes it as the walkway near the portable buildings located north of the band parking lot. So
let's do this, Mr. Herrera. I'm going to appoint you a lawyer today so we can get down and dirty with your case a little bit more. Just take a seat for me in the jury box. Let me get you a lawyer, okay? Ma'am, you were charged with assault, bodily injury. You were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
yes, Judge. On February 9th, 2025, the officer made contact with the complainant, who advised that she and her husband and friends were outside by their motor vehicle hanging out, and the defendant was saying things to them about them being illegal. The complainant and the defendant started getting into a verbal argument, and the defendant started to attack the complainant while the defendant was holding her baby and was reaching around the baby trying to fight. The complainant advised she sustained injuries during the assault and was in pain and was in fear for her life. The officer observed the complainant to have scratches and whelps on her right arm.
Hate crime? Ms. Riverbark, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with these people and not to be in possession of any weapons. If I find that you're a danger to my public, and I don't care who it is, I will revoke your bond, put you in jail, and I'm going to make your bond sky high. Do you understand? Do we know if alcohol played any kind of part in this?
There's no allegations of alcohol, Your Honor.
And filing those conditions, no contact, no going within 1,000 feet of where this person lives or
Yes, sir.
works, and then no weapons, please.
Yes, Judge.
Ms. Riverbark, you have the ability to hire a lawyer. Okay, we're going to reset your case to give you time to hire a lawyer. I will have you sign a reset with Victoria. After that, I'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go, man. Good morning, Ms. Singleton.
Good morning.
And you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. The officer was dispatched to an apartment complex on Dominion Park Drive. and met with the complainant, who advised that the defendant is Herreri. The complainant stated that the two had a verbal argument over rent, which led to the complainant gathering the defendant's personal belongings and throwing them outside of the residence and onto the ground. Approximately 100 feet from the front door, the defendant then walked towards the complainant and struck her on the face and torso with a closed fist, causing the complainant to lose balance and fall to the ground. The defendant continued to strike the complainant until the defendant's boyfriend pulled her away. The complainant advised she felt pain.
Singleton, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with this person. It looks like a protective order was issued on the 8th of this month. I would get to know it, because if you do something to violate the protective order, like go to the house that's listed in this thing, even if they give you permission, the state can and will file a violation of protective order. It's one of the worst cases you can pick up. Do you understand? You're also not to be in possession of weapons as well, ma'am. No. Contact. No weapons. Ma'am, do you have the ability to hire a lawyer? Okay.
I can.
I'm sorry?
I can.
You don't want to apply for a court-appointed lawyer?
Thought I had one.
No. You have one during magistration just for that very purpose, but that it ends at that stage. It doesn't carry with you forever. So at this moment, you don't have a lawyer. Do you want one?
May I have a court appointed?
Okay. I have an application on file, Deputy Marine. Don't worry.
Oh.
I have an application already on file. I will have you sign a wreath of Victoria. Don't be a danger to my community, because I only have one place for you if you are. Do you understand?
Sure.
You won't get another warning. Octavian Edwards. Mr. Edwards, you're charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 7th, 2025, at approximately 10:04 p.m., the officer observed a vehicle with an expired registration as of December 2023. A traffic stop was initiated, and the officer made contact with the defendant, the driver, and sole occupant of the vehicle. The officer smelled a strong odor of marijuana and observed the grip of a green handgun underneath the front center folding third seat, directly within the defendant's wingspan. The officer asked the defendant how much marijuana was in the vehicle, and the defendant stated 7 grams. A PC search was conducted, and the officer retrieved the handgun, which was loaded and unholstered. The officer also located a marijuana cigarette and 2 clear plastic bags containing a green leafy substance recognized as marijuana in the center console with a weight of 3 grams.
All right, Mr. Edwards, I'm going to find that there's probable cause to go forward with your case. I am ordering you as a condition of your bond not to be in possession of weapons. Do you understand?
Yes, sir.
Does he have a valid Texas driver license?
It appears that his license is expired, Your Honor.
You don't have a license. You're not allowed to drive. I don't care what's going on in your life. If you want to drive, go get a license, get liability insurance, and then I can take this restriction off. But if I find that you drive, it's really not going to go well for you. Do you understand?
Yes, sir.
You will be signing a promise with me. This is an affidavit that you're not going to drive. And I hope that you heed this warning, because I take it absolutely seriously. I don't care what's going on in your life. I don't care if there's a burning building. You have to go save 50 kids. Don't drive. Shoot.
There was another firearm in my vehicle. It was a rifle. Do I have the right to?
You need a lawyer. I can't give you legal advice. The only thing I'm telling you is I don't want you in possession of any weapons. So don't, because I'm going to put you in jail if I find that you violate these conditions. No more PR bonds. Do you understand? A lawyer can answer all these questions for you. I'm just not allowed to give you legal advice. Do you have the ability to hire a lawyer, sir? So what I'll have you do is I'll have you fill out an application. Let me take a look at it to see whether you qualify. And if you do, then I'll give you a lawyer. But above all else, do not drive. All right, I'm going to have you come up here, swear to us that you're not going to drive. I'm going to get you to Victoria, sign a reset. We'll have you take a seat in the jury box. Do not leave until you sign our bond conditions as well. Mr. Sains, you're charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 180 days in jail to be probated. I'm sorry, not to be probated, with 67 days in jail to give you credit for. And it looks like you also have a terroristic threat. It looks like they're going to dismiss this case as a result of this plea bargain. Is that how you understand it? You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, you give up the right to appeal. Is this what you want to do?
So,
How do you plead to the offense? Guilty or not guilty?
yes, I guess
I'm sorry?
Guilty to the criminal trespass that we talked about. You're pleading guilty to the criminal trespass, do you understand? And they're dismissing the Paris statement, so they're not guilty. So you're gonna say, so you understand? That's the same. You have to tell the judge that.
thank you, sir.
Are you guilty of the criminal trespass?
Sir.
Okay. You know what we're doing, right? That it's going to go on your record. From now on, you're facing a minimum of 30 days in jail, all right? If you go back to, where was it, Alex?
Your Honor.
Time-wise.
The trespass was at an exam, Your Honor.
If you go back to this McDonald's, you will end up going back to jail. So you can't go back to this McDonald's, all right? Okay, sir. Good luck. Thanks. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Yes, Judge. On February 7th, 2025, at approximately 10:08 p.m., the officer was dispatched to a major crash on the 200 block of South US 50 freeway in Harris County, Texas. The officer met with other officers at the nearby gas station where they had moved the scene. The wheel witness stated she was rear-ended by the defendant and was able to put the defendant behind the wheel of the vehicle. The officer observed front-end damage to the defendant's vehicle, and the officer made contact with the defendant, the driver, and occupant of the vehicle. The officer observed slurred speech, staggering, and disorientation and confusion. The standard filtered writings were conducted, HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The defendant stated he did not drink any alcohol that day, and the defendant was read the DIC and refused to provide a breath specimen. A blood search warrant was signed and executed.
Williams?
The judge sounds like there's no probable cause because US 50 is not in Harris County, Texas. It's what the road they said it happened on.
Where is it?
It said US 50, that's not in Harris County.
And the DIMS does say 200 block of South US.
Are you serious?
It says-
Do I need to look it up? I don't know.
Your Honor, the DIMS further says during the scene of the accident, which occurred on 200 block of South US 59 freeway, Harris County, Texas. But counsel is correct that before they said he responded to a major crash call for service on the 200 block of South US 50 freeway. So they put 50, but then later in the DIMS, they just put 59. So they're just two addresses, so I don't know why that's there. But they did say the accident occurred on US 59.
Well, that would be a different story.
Do you have any other evidence that is pointing to that it's at 59 or is it 50?
So, Your Honor, the only thing we have is that statement from the officer, which states that the accident occurred on 200 block of US 59 in Houston, Texas, 77004.
Is that what really happened or was it on 50?
So that's what I can explain is the officer put.
I'm not working on hunches here, man.
And I understand, Your Honor. The officer initially said he responded to a crash call for service, which occurred on US 50, but then later said the accident occurred on 59. So let me see if we
definitively point
it is. I'll check the OR and see if they clarify in the complete OR. And in the OR as well, the officer says, which occurred on 200 block of US 50, Houston, Texas, 77004.
So is 50, it's not in Harris County?
He switches between 50 and 59 in the offense report sheet.
I know probable cause.
Yes, Judge, and we understand.
All right, Joe.
Thank you, Judge.
All right, Mr. Lozano, be careful out there. You know what I mean? Really. Just listen to, he's great. He'll help you out whenever you need, you know? All right, man. Good luck.
Excuse Judge.
Report at Law 5.
How are you? Have you been to the Van Gogh Museum?
No, sir.
It's great. It's awesome. Man, it's really cool. You should go one day. How are you?
I'm good.
How old are you?
I'm 15.
He's awesome. He's so great.
He was looking
You
forward
got to
to meeting-
follow
He
him.
was looking forward to meeting you, Judge.
Here, how about some candy? We have some cookies over there too, if you want some cookies. Oh, can I give him candy?
It's all good. He's 15. He can make his own.
Well, I don't. You got to follow in his footsteps. You know, that's what it's all about. Knowledge is power. When you know things, you go so far in life and you get money. That's what counts, right? Yeah.
Appreciate it, Judge.
If you ever want to come hang out and watch what we do, stop by. We can have you sit in the chair over there and just kind of hang out and just watch what we do. Yeah,
Sounds great. Thank you.
absolutely.
We had a day off, so I figured
I know my kids are off too.
Yeah, yes, sir.
We're gonna go to the movies now. I'm just gonna go see the Marvel movie.
Everybody have a great weekend.
Yeah, you too.
Thank you, Judge.
Okay, bye, Mr. Brooks. So are we done?
Yes, Judge, we're done.
All right.